I'm just going to say, here we go. Everybody should have gotten a pop-up on your screen. Everyone, welcome to the Recent Graduates Chapter's free online CLE presented by Professor David Stout. Thank you so much for joining us. We have over 70 people registered. We'll hopefully get a few more people to log in, but we're thrilled to have everyone with us. My name is Melissa McGee. I'm a 2017 graduate, and I'm the president of the Recent Graduates Chapter. Just a really quick kind of overview about what the RGC is. We were created by the Alumni Association with the goal of serving and supporting alumni who've graduated within the last 5 years. Each class from the last 5 years has 2 representatives on the board. Our goal is to represent our classmates and help support and engage you with other graduates, the Alumni Association, the law school, and the overall legal community. I encourage everyone to reach out to the RGC if you have suggestions or comments on anything you would like to see us do, whether that be some more free CLEs like we're doing today, social gatherings, professional development, or any other activities that you think would be helpful to recent graduates. We really want your feedback and your ideas. We really can't do it without you guys. So please reach out to us and submit your ideas and thoughts. A reminder for this CLE to submit your CLE credits by December 15th via the form that Melissa sent that was in the email. It's important to do that by the 15th or else it won't get done until the new year. So just a reminder on that. I just really quickly want to thank the Alumni Association for creating the RGC and giving recent grads the ability to stay engaged and active in the alumni community. I also really want to give a big thank you to Melissa Lobato for all of her hard work and help with this event and the RGC generally. You all know her and we all love her. So thank you, Melissa. So now to the main event. Thank you so much to Professor Stout, who graciously agreed to give this presentation. We all know him and we're very excited to have him here with us today. So Professor Stout, I will hand it over to you.
Great. Thank you, Melissa. And welcome everybody. Good afternoon. It's really pleased to see at least all of your names, and I'm grateful for this opportunity to spend a little time with you this afternoon. My thanks to the UNM Recent Graduate Chapter of the Law School's Alumni Association for this invitation. Because you will receive an ethics credit for this hour, I thought it would be good to have some content that would satisfy the CLE requirements. Though I can tell you I would much prefer hearing about all of the interesting and exciting things that you all are doing. But barring that, we will forge ahead. I'm really going to talk about 3 things. The first thing I'm going to talk about is just give you a very brief update on some of the important rules that have come out recently that I think are generally relevant to what we are all doing. Then I'll move to the scenarios, which you should have received in a set of materials. Obviously, we're not going to get through all of them in this hour, but we'll try and get through a number of them. And then I've got a couple that I thought of sort of after the fact. And then finally, I'll have a few brief remarks about professionalism and survival. I think most of you know that professionalism and how we survive as lawyers are important topics to me, and so I'll spend a little bit of time talking about that. And if someone could give me a shout out, Melissa, either of the Melissas, when there's about 15 minutes to go, that would be great. So the first thing that we want to talk to you about are some of these new rules that have come online. And the first rule is 16.119, and that's not something that is of immediate concern because there's a sort of a break-in time for that particular rule, but it's the succession rule. And the idea is that, God forbid that something happens in the way of a stroke or some sort of catastrophic event that disables the lawyer or kills the lawyer. And what happens then to the lawyer's clients? Well, for people in firms, the firm is going to take over. And for people who are working in government jobs, that's not going to be an issue. But it is an issue for people either in a very small practice or in a solo practice in particular. And that's really what the rule is intended to address. And it basically requires that you have at least some kind of plan. My plan, I do very little work anymore, a little bit of appellate work, some consulting, but rarely have cases that I'm doing, solo, and certainly no litigation. So my succession plan is going to be really simple. I'm going to have something like, George Bach will take over, what few cases that I have. It'll be something along those lines. Obviously, the more complex your practice is, the more complex your succession plan may have to be. But I think for most of it, it's not going to be a big deal. You need to be aware of it, and you need to start thinking about it. So that's 16.119. This isn't really a rule, but it's a jury instruction for those of you that are practicing in the civil law. And it's a new instruction. It's 13.208, which basically directs the jury that insurance has no bearing. I think this instruction finally recognizes that everybody is, pretty much aware of the existence of insurance, and therefore it addresses it for the jury sort of preemptively. There are certain circumstances where insurance can be relevant, and the new instruction will take those circumstances into account. Finally, there's some fairly major. They appear to be more major than they are. And these are revisions to the rules of professional conduct 16.701 through 16.705. Basically, these rules bring New Mexico in line again with the model code, which was amended a couple of years ago to make some changes to the advertising rules, advertising and solicitation rules. Essentially, all of those 5 rules, 16.701 through 705, are consolidated into 16.701 through 703, and 704 and 705 are discarded. That's the primary change that has occurred, is that consolidation. There are some variations with regard to electronic media in particular that are included within the rules, but for the most part, they're fairly minor changes. But you should be aware of that, particularly if you're in a firm that does advertising. You need to go back and check and make sure that whatever content in whatever forums that you are advertising your firm still comports with those rules. So that's really the first group of things that I wanted to chat with you about. And again, just bringing them to your attention. So let's talk about some of these scenarios. And I'm going to start with scenario 2, which I've called the reluctant judge. I think all of us have had, or many of us have experienced this particular set of circumstances, which is basically that there was a pending motion to dismiss that hasn't been resolved. It's been briefed and argued for over a year. There are motions to compel that are piling up. One motion is set for hearing, but the other motions have not been set for hearing. Nothing is really happening in the court. You filed a request for a status conference, but haven't heard anything, and the request is now a couple months old. Essentially, the request is at a standstill. The case is at a standstill. And so opposing counsel is perfectly content to allow the case sort of to, stagnate until such time that the motion to dismiss is resolved. And of course, what always happens is that the pretrial deadlines are approaching, and there's already discussion about extending the motions deadline or extending the pretrial deadlines. Your client is going crazy, and you've considered writing a joint letter to the court advising them of sort of, the motions that are stacked up. But the last time you sent a joint letter to the court, you got a sort of a nasty response from the judge's assistants about ex parte communications. The judge is very well liked and is always cordial, but you are having a very difficult time with your client. So this problem raises the question, what are your options? Well, your first options are to know really what the rules are that might pertain to this particular circumstance, and then recognize that maybe the rules don't provide, any type of complete answer. And so the first rule is 16803, and that rule provides in section B, misconduct of judges. And a lawyer who knows that a judge has committed a violation of the applicable rules of judicial conduct, that raises a substantial question as to the judge's fitness for office, and that's the key phrase, shall inform the Judicial Standards Commission. Well, what are the relevant rules that a judge might, in these circumstances, might be violating? Well, it would be 21205, which is a judge shall perform judicial administrative duties competently and diligently. And so there would at least be an argument that the judge is not engaging in diligent administration of his duties. And so I guess the question becomes, should you file a complaint with judicial standards? Do you have a basis? Well, it's a fairly thin reed to file a complaint with judicial standards. For the simple reason that the rule itself requires that it calls the judge's fitness in office. Now, we could be frustrated with it, but it's not, the circumstances don't indicate that the judge isn't fit for office. It's just not getting the job done. And so probably filing with the JSD, aside from the potential impact that may have on the representation and your relationship with the judge, is certainly something that you would want to consider. And what of your client? Have you described your options to your client and your client says, yeah, fire away, full speed ahead? Well, that's a circumstance that you're going to have a serious discussion about it, because there certainly is a downside. So what are some of the other options that you might contemplate or pursue? Well, you could send a joint letter to the presiding judge, or you could send a letter to the presiding judge explaining what's happening. And if the presiding judge may bring this to the attention of the judge that you're having the problems with, that's a possibility. What about a writ of superintending control? Another possibility. I mean, that's that again is going to escalate the situation if you basically direct the court to tell the judge to do their job. But that's a possibility, and certainly in a writ like that, you would want to lay out all of the particular facts that are creating the problem, because the docket is clogged. I think it's also worth contemplating, could you get opposing counsel to participate in the request so that it actually becomes a judge request or a joint request? I mean, these are particular questions that they're not easy questions, because as we've discussed, you run the risk of alienating the judge, which is never a good idea when you're seeking to represent counsel. It is a frustrating situation, and I think it's exacerbated by the fact that we're in a pandemic, and all of our practice has sort of been turned upside down. I mean, I'm extremely cautious these days to get after judges, and in my case, those are appellate judges, because we can't get decisions out of them. They've got a lot on their plate right now, and that's something that has to be considered. That circumstance came up a lot when I was, in a practice on a regular basis, and I never came up with a good explanation. I mean, I've tried the presiding judge route, haven't tried the writ of superintending control, and ultimately have not had a great deal of success, other than to beg for a hearing where you can get in and say, look, judge, we're not going to have the opportunity to address all these things if and still to keep our trial date. So that's really the first scenario. I wish I had categorically good answers for you, but I really don't. Other than these are things that you can consider, options you can consider. I've never done the nuclear option of filing a complaint with judicial standards. Okay, so let's take a look at scenario number 3, and that's the helpful lawyer. This actually happened not in a trial, which is the scenario, but in a deposition. So the setup here is that you're at trial, and you're questioning a witness. And you ask whether that the witness had met with opposing counsel. And here I just arbitrarily picked plaintiff's counsel. And the witness says yes. And so you ask the witness on the stand what they discussed with counsel. This is a third party witness. And the witness said that when asked if any of the plaintiff's lawyers gave him any suggestions or instructions, the witness said yes, pointing to plaintiff's lead counsel. He told me I didn't have to try and remember everything, and that the fastest way for me to get back to work was just really to say, I don't remember. So the question is, what are the obligations here, and what are sort of the options that you have? Well, again, going back to knowing the rules, it's pretty clearly a violation of 3.4a or 304a. So I still am tied to the model rules. And that provides that a lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. So it's really obstructing another party's access to evidence, potentially. And so, this occurs in a trial setting. So theoretically, the judge should jump on it like a starving trout and address this particular problem. And so what's the judge going to say? The judge is you're going to ask the judge, if you're the defense lawyer here, to direct the witness, that the witness is to answer the questions, to the best of their, truthfully, to the best of their particular recollection. I mean, that might take the form of the motion if the judge hasn't done anything, hopefully the judge was listening and heard the testimony. So what are the strategic? Is it a basis for a mistrial? Might be. I mean, it might be a basis for the plaintiff's lawyer to ask for a mistrial because the potential prejudice, because it was said in front of the jury. There is that particular potential, and certainly it's a violation of the rules. And so the question is, if the trial continues, at what point do you file the motion for or send a note to the disciplinary board making a complaint? This is a situation again where the judge really should file the complaint because it's a blatant violation. And but if not, certainly the lawyer has an obligation under our rules of reporting misconduct to file that particular complaint. And in our case, in the case that I was referring to in the deposition, we filed a complaint with the disciplinary board and do not know the result of that particular complaint. Okay, so let's do scenario number 5, which is the lawyer responsible for the investigator? And so this is a fairly simple setup. It comes out of a trial setting where the lawyer really wants to investigate one of the jurors. And so the lawyer has an investigator check out the juror's internet presence and finds out that the lawyer has a Facebook, or the juror has a Facebook page. And the lawyer tells the investigator simply to check out the Facebook page. So the investigator on her own makes up a name and sends the juror a friend request. And the juror accepts the request, and the investigator is able to access the juror's non-public postings. And so is there a problem? Well, there is a problem. On the one hand, all the lawyer did was to say to the investigator, check out the Facebook page. But there's some ambiguity with regard to that request. And so what the scenario really poses is the difference between public and non-public information on social media. And so, again, returning to the rules, it's pretty clearly a misrepresentation. The investigator has falsely represented who they are by making up a name, sending the juror a friend request, which would appear to be an ex parte communication. That is a violation of 305B. And so there's a 401 misrepresentation. There's also, an 804C failure to engaging in conduct that involved dishonesty, fraud, deceit, or misrepresentation. And also it would be under 804D, which is conduct that is prejudicial to the administration of justice, sort of the, the familiar catch-all. Of course, the lawyer didn't do it. I mean, it was the lawyer's agent in these circumstances. And so that implicates 503 and 503B in particular, that a lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And so there's a limitation on that. It's not categorical. And the limitation is that the lawyer's responsible for the conduct of such a person that would be a violation of the rules of professional conduct if the lawyer engaged in the conduct, which is our case here, but only if the lawyer orders or with knowledge of the specific conduct ratifies the conduct. Or, and there's another provision where a supervisory partner with managerial authority knows of the conduct at a time when the consequences can be avoided or mitigated. So, I mean, that's the out for the lawyer when the third party violates the rules of professional conduct that would be a violation for the lawyer. And so these particular circumstances, or the social media circumstances, have been addressed. And I just want to point out that the ABA, has formal opinions, that hundreds of them, literally, that address, many, many important and different elements of our rules of professional conduct. And I urge you that if you have an issue that comes up in practice, don't forget that that's a source of, not only is it a formal opinion, but it collects the law, nationally, the law on a particular area. There have been some recent ABA opinions that deal with, Zoom activities, Zoom depositions, Zoom hearings, working with clients during the pandemic. So they try and keep up to date with the types of ethical issues and problems that arise out of our practice. So returning to our problem, there's a couple of relevant points to take away from this. And the first one is that there are opinions out there that say, hey, if you don't check out the juror's social media presence, you're not providing competent representation to your client. And I think, those of us who try cases, the jury would agree with that that's pretty fundamental to see if the jury has a social media presence and what that actually says. What you can't do is what was done in this case. All right. That's a bridge too far. And so, the internet presence can be examined, okay, but the lawyer can't communicate directly or through another with a juror or a potential juror, okay? And so, an access request is a communication to a juror, asking a juror for information that the juror has not made public, okay? And that would be the type of ex parte communication that's prohibited by 305B, all right? And so you can look at the presence, and even if the juror becomes aware that, one of the lawyers in the case is looking at their social media presence, that doesn't constitute a communication, okay? Because it's not a direct communication. And so that's the takeaway from this particular scenario, is that important distinction between public and non-public information on a social media presence. Okay, so this is a problem that I came up with as I was sort of working through these areas. It's not in the material, so I'll just briefly outline it for you. And it is as follows. Sally has been working a series of depositions with Luis, another lawyer in her office. And Sally's been taking most of the depositions and has been attending the few depositions taken by Luis, as she is the one that's most familiar with the case and is lead counsel on the case. So Sally notices that when she is taking the depositions, the male opposing counsel is constantly objecting. But when Luis takes the deposition, opposing counsel is virtually silent. And opposing counsel once referred to Sally as the little lady and consistently ignores her emails while responding to Luis's. So what are Sally's options? Well, I wanted this scenario. This scenario is, maybe too familiar with some of you, for some of you, and I hope, which would be unfortunate, but it's still a problem. And so maybe there are a couple of things that the lawyer can do. And the first thing I think is, to simply confront the problem and to remind the lawyer that New Mexico has adopted a rule of professional conduct that prohibits discrimination on the basis of sex. And that's 16804G, which makes it professional misconduct to engage in conduct that the lawyer knows or reasonably should know is a form of discrimination on the basis of various prohibited categories, including sex. And that is a violation of our rules of professional conduct. It's also highly unprofessional conduct. And there's a lot of information that is out there, published by the bar. There are various commissions on the status of women in New Mexico, for example, and various other bar organizations that provide information on exactly this type of what is essentially unprofessional conduct. And so perhaps a letter reminding opposing counsel of the existence of not only their professional obligations, their professional obligations, in addition that their conduct is governed by a rule of professional conduct. The other aspect that this problem raises is, what about Luis? And if Luis is, let's look at this in two different ways. First of all, Luis is a junior lawyer, and so if Luis is a junior lawyer, what's his role in this? Because clearly he's going to have conversations with his co-counsel from the office and discuss that. And so maybe this is a situation where that Luis says, when he gets an email response from the lawyer, responding to what was essentially an inquiry from Sally, that she's the one in charge, and that his opposing counsel needs to go through Sally. So this is a circumstance where I think it's important for male lawyers to recognize that they need to be allies of women who face this type of sort of, discrimination in the practice or unprofessional conduct. And there are various ways to be allies, and that is to boost the voice of the person who is not receiving the respect that they are due. And so I wanted this scenario, I think, is important. We keep running into it. You all know my daughter is a lawyer in town, and she continues to experience, and she's been out 10 years now, various forms of what I consider to be highly unprofessional conduct, treating her differently than the male lawyers in her office. All right, so let's move on to, I'm going to skip scenario number 7. Let's move on to scenario number 8, the emailing lawyers, or what an asshole number 1. Excuse me. So this is the case where there are two lawyers that have engaged in, sort of this, email exchange of insults. Insults which become really very personal toward as the circumstances have escalated. The setup is, one is a lawyer that's been out for 30 years, and the other is a younger lawyer who's been practicing for 3 years. And anyway, they engage each other and finally end up, making very personal and derogatory insults about the lawyers' families. I will say that this is taken from an actual case, and the string of, I distilled this down considerably, but this string of emails went on for 15 or 20 pages of these two lawyers exchanging insult after insult. It was just awful. Both of the lawyers in the case, by the way, ended up being disciplined. And so what do you do in a situation like this? Well, it seems to me that somebody's got to be the adult in the room. And if that's the younger lawyer, then that's the younger lawyer's role. You try and de-escalate the situation. It's a totally counterproductive exchange on this. And this was, a loan case, basically. And so the setup does say that, a motion to compel is filed, and much of the email correspondence, is attached as exhibits, and, what a wonderful idea that is. So it's not a situation where there's a whole lot you can do, because both lawyers have engaged in the conduct. I mean, they're equally guilty here. And it's conduct that's likely to draw the wrath of the judge. And so maybe the thing to do is to, seek to de-escalate the situation, say, hey, this has gotten out of hand. Let's step back and, we've got to act, and try and remember how adults act and how adults, resolve circumstances, and see what, that's the type of letter or the type of email that ought to be, one, it ought to be done for the sake of the clients in the case, but also, if this is going to end up being resolved by the judge, that's the sort of letter that, you want to say, look, we tried to resolve this, or I tried to resolve these particular circumstances. And this is the response I get, and see what response you get. I mean, I think, and this is a situation that you may be able to actually, do something by just saying, look, both of us have been out of hand. We've got professional responsibility, obligations, and let's try and get this back on track, because it's not to anyone's benefit, including the court's benefit, especially the court, I would say, and the clients, to have gotten involved in this particular situation. So I want to go from there over to scenario number 10, because that's sort of a different circumstance that follows up on where both lawyers are engaged in this type of activity. So this scenario is that it's a young lawyer who has a busy practice. They're just learning things. They've filed a motion to compel that includes a description of the good faith efforts to resolve the dispute. The young lawyer has made repeated efforts to contact opposing counsel by phone and by email, but all of the efforts have been ignored. You've left messages with the lawyer's secretary. The lawyer is a partner with a big name reputation in the community. And so after the motion is served, you get a phone call finally from this lawyer who, reams you out, claims you've made false statements in the motion, claims that the motion is frivolous and that you failed to engage in meaningful efforts, and threatens to file a disciplinary complaint for lying to the court. And the lawyer goes on and on for 10 minutes telling you that they will personally ruin your career if you don't withdraw the motion. They'll never work with you again. What should you have done, and what should you do? And this is actually taken from a call I got from a young lawyer, a couple of months ago. The first thing I would say is never take that abuse. Never take that abuse from opposing counsel. All right. You calmly interrupt and say that you're not going to put up with verbal abuse. And when the person is willing to have a civil conversation, you're more than happy to do so. And if the abuse continues, you hang up and you write a follow-up letter. Okay. And so that to me is, how you've got to at least initially handle that situation. You can't allow the accusations to go, unresponded to, because that's going to end up in emotion. So I think you've got to write a letter, after that happens. I mean, a couple of other things that, I've thought about from time to time, and that is, maybe you say, just a minute, I'm going to record this conversation. That can have two effects. One, it can escalate the situation, that potentially at least. And, but on the other hand, it may get the lawyer to think that, what they're putting down here is something that, is going to end up in a transcript, or it's going to end up being played back to the lawyer. So although there's a risk of escalating the situation, it also might, get the lawyer to calm down. So should you file a disciplinary complaint? Well, the should you file and can you file are two different things. And here you might have a basis for a disciplinary complaint. All of you should be familiar or become familiar with the In re Ortiz case, which is 213 NMSC 27. And that's a case where a lawyer was disciplined. There were extenuating circumstances involving potential behavioral issues with the lawyer, but the court was pretty clear about the type of conduct that the lawyer had engaged in being a basis for discipline, and serious discipline at that. And so how did the court, what was the basis for that? Well, the court's basis was that a lawyer can't engage in conduct that is prejudicial to the administration of justice. And that type of abuse or abusive language that is directed at opposing counsel qualifies for conduct prejudicial to the administration of justice. In addition, the court looked at 16404A, which is prohibited conduct to third parties. And the court finds, implicit in the court's opinion is that when a lawyer abuses a lawyer, they're abusing a third party. And so the court used 404A, which provides that in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third party. And that's what the court, hung its hat on with regard to the statements that were made by the lawyer that was disciplined in that case. And the point is that it is a basis for discipline, and it might, under these circumstances, might qualify as a disciplinary complaint. What's the lawyer going to do? Probably the lawyer's going to deny it. Okay. And maybe it goes nowhere. Maybe it escalates the circumstance. Anyway, there's certainly something to consider. The court also, I will say, looked at our professional conduct rules in 15304, that the lawyer shall maintain at all times, this is from the oath that you all took, abstain from offensive personality, advance no fact prejudicial to the honor or reputation of party, maintain civility at all times. That's important to the court. I mean, all of you were, I think, young enough, recent enough that you had to take the 2-hour class on professionalism that Justice Chavez instituted when he was Chief Justice. So a couple of thoughts on that particular circumstance. The takeaway is, just don't allow the lawyer to be, no one has to experience abuse from another lawyer. Scenario 11 was, sort of just a reminder that if you get something that, sets you off from opposing counsel or from in a non-transactional, in a non-litigation context, in a transactional context that is upsetting to you, it's okay to draft, a nasty response. It's another thing to send it. And this is just the reminder of the Truman letter. The story is that, Truman would, when he would get pissed off about something, he would write a letter and then he'd stick it in the drawer and just let it go. And I think that's not a bad thing to do with emails. I mean, responding in a moment of anger is not the best way to handle a situation. And if you take the time to reflect on it, to get away from it, not only will you do a better job of sort of drafting a response to something that is uncalled for, but it will give you a different perspective on the matter. Let's see what I've got. We're in good shape. Okay, so scenario number 9, the inattentive lawyer. This is sort of the flip side of the inattentive judge that we've got, and it's something that is a completely frustrating situation. You've been the setup is that it's a litigation setting. Case has been filed. There was a scheduling order in place, and after the scheduling conference, which was attended by both you and opposing counsel, the court sends out a scheduling order, which was sent to all counsel by the e-file system. Your office calendared all the deadlines, and for the next several months, you timely file your fact and expert disclosures. Fact witness and expert witness disclosures. But opposing counsel doesn't. And there are significant issues getting the mediation set because of the parties and counsel's availability. And so you agree with opposing counsel to enter an order extending the mediation deadline. There are emails between you and opposing counsel discussing the concern or your concern running up against the court-ordered deadline. Mediation was finally scheduled in the discovery deadline and after the discovery deadline and the dispositive motion deadlines. Well, a week before the mediation, you received a letter from opposing counsel advising that he and his paralegal were not on the email from the court filing system for the scheduling order. And thus none of the deadlines in the case were calendared. And opposing counsel asked whether you will oppose this motion and allow him to file the fact and expert disclosures late. The motion also asked the court to vacate the trial, which is set in 6 weeks. So you don't have to practice law very long before you run into a situation that, sort of like this. This is maybe an extreme example, which is totally frustrating. And I guess out of the facts of this case, there were cues to opposing counsel that there were deadlines. I mean, you were filing your own fact and witness and expert witness deadlines. You'd exchange correspondence discussing court-ordered deadlines. So, I mean, there's pretty good case here for gross neglect or willful ignorance on the part of opposing counsel. And so there's a pretty good basis, legally to oppose the motion. You've got a client, you've done the job, you've done the work, the trial, you want to keep the trial date if you possibly can. And so, do you want to, what are your options? Well, I think you almost have to oppose the motion, in consultation with your client, but maybe you can agree to work something out. Maybe it's possible in this situation that you can enter a stipulated order in exchange for not opposing, an extension that sets narrow deadlines and allows you to keep your trial date, and at the same time get the discovery done and get the work done that opposing counsel had failed to do in a timely fashion and when they should have done it. Maybe you get a hearing. I think you would certainly try and get an expedited hearing, and some judges, you may be able to get that, and other judges maybe not, especially in these times. But it's a frustrating set of circumstances, and so I think that the other takeaway about this would be, keeping on opposing counsel to make sure that everybody's on the same page. The setup here suggests that they weren't filing expert witness the expert witness identifications and identifying fact witnesses, and that surely would have prompted or should have prompted a communication from you saying, okay, now where are the specific where are your identification of witnesses and experts, and why haven't you sent them? So maybe the entire set of circumstances could have been avoided with a simple email or a phone call. Okay, so
Professor Stout, you're just 1 minute away from 15 minutes.
Okay, all right, great. Thank you, Melissa. I think we can cram in maybe one more. Let's see. Yeah, there was one more quick scenario that I think we could do. Oh yeah, very quickly, and then I'll head into the wrap up. But I mean, scenario number 12. Whose fault is it anyway? This situation is, just a reminder about taking responsibility when you mess up. And so this happened to me, by the way, which is why I'm using it. You missed the deadline for requesting a jury trial, and you rely upon the legal assistant that works for both you and your supervisor on the case, and it simply wasn't calendared. Okay, So you now have to go to your supervising attorney, or in this case, it was my partner, and give them the news that we will not be able to have a jury trial because we missed the deadline. Okay. And you're afraid that that will not, that the case may not go well in front of the judge, which you cannot excuse at this point in time. So how do you handle the situation? Well, you can try and get opposing counsel to agree to, to the jury trial and cure it that way. But if they're unwilling to agree to it because they see some, strategic advantage to a case tried to the judge, I mean, you've just got to take responsibility for it. Because it's your responsibility. It's not your assistant's responsibility. Calendaring is the lawyer's responsibility, or it's a joint responsibility that should be shared. And those important deadlines, like asking for a jury trial, have to be taken into consideration and taken care of. The irony of the case was it was a federal court case. And we probably, we're in a better situation to have the particular judge that was assigned to the case try the case than we would have been with a jury. That was not my plan. I can tell you that when I didn't file the instructions, but it turned out that way. Okay, so let me have just to sort of conclude our session today. I have a couple of thoughts on, sort of longevity and how to get the most out of your professional experience. So why did I choose today's title, 40 Years and Still Counting, Reflection on Ethics from an Old Dog? I guess there are three reasons. First, I've been practicing law one way or another for the past 40 years. And I find that fact in and of itself to be, remarkable, if not astonishing. And second, I've witnessed a great deal of lawyering over that time, good, bad, and indifferent. And third, for the most part, I've enjoyed that time and have valued the opportunity to have been part of this profession. Conversely, you are all at the sunrise of your careers, and you have discovered the learning curve is steep, if you're like me, and the pressure is probably beyond what you might have anticipated. If you were like me, you might have some lurking doubts about your ability to do this taxing work, or even some questions like, have I made a terrible mistake? Those questions for some of us, I think, are natural. You add on a pandemic and its challenges, both professional and personal, and you have quite a mix for starting the early years of your career. So I've become obsessed with a concept that I want to share with you, which is from an unlikely source, actually, David Gessner's biography of Edward Abbey and Wallace Stegner, that includes the following description of the biographer's challenge. Gessner writes, quote, "It is certainly not my goal to maintain a false front image of the man," and he's talking about Edward Abbey. "Biography cannot reform the truth, but there is another use for biography, one that involves, in Stegner's words, a search for a usable past," unquote. A search for a usable past. What an interesting concept. That biography, that the unique characteristics that define our lives become markers along the road of our journey, and in some way become part of a usable past. So in thinking about what to tell you today, I have attempted to search out parts of my usable past that may be of some benefit to you, knowing that we have to gird ourselves for the long haul, that the quest for an enduring, full professional and personal life is a long race and not a sprint. So I've got a couple of suggestions. First, cultivate humility. For me, that means to remember that we are all warmed by a fire that we did not build, that any success is invariably the result of many hands working together. If you accept that you are as great as your ego would have you believe, I think that's a surefire way to resentment and dissatisfaction. You are not going to prevail in every case or in every argument. In the practice of law, my experience has been that there is always someone who is smarter, quicker, cleverer, better on their feet, and more creative. Absolutely none of which is in any way relevant to our being good lawyers and providing our clients with excellent representation. A companion to cultivate humility is don't ruminate on what ifs. Accept with gratitude where you are today and don't regret what might have been. Second, learn to identify the little failures. The big ones are obvious. So Samuel Beckett in his play Westward Ho penned these lines: try again, fail better. We have all heard the old saw that you learn more from failure than from success. And like all old saws, there's truth found in the generalization, although there are some dissenting voices on that particular point. But that's not really what I'm talking about. What is beneficial to both success and longevity is to have sufficient awareness, sufficient self-awareness to actually know when you could have done something better and to reflect on why you did not. Was it a lack of time? And if so, what caused that? Was it a lack of preparation? Was it a lack of effort or of interest? That type of introspection is valuable, I believe, not only from a professional standpoint. The lessons there are usually obvious, but it may also serve to make you question how you are living your life and how effectively you are balancing the personal with the professional. I've experienced both professional and personal failure. It took the dissolution of my first marriage of 16 years after about 10 years of practice and a clinical depression to do the type of self-examination that I should have been doing all along. Don't make that mistake. 3, learn to forgive, or if you prefer, cultivate tolerance. So those of us who practice in litigation know that we have to deal with difficult personalities on a fairly regular basis. But dealing with difficult personalities isn't limited to litigators, nor to lawyers for that matter. Just ask Nancy Pelosi. Dealing with the difficult personality or the asshole can be a regular challenge. Okay? So learn to ignore the bully and the braggart. Engagement only encourages the behavior. At the same time, identify what must be addressed. I mean, there are times, when you're accused of things that you have to address it. So if there are relevant misrepresentations, then they've got to be addressed. But forget the rest. Okay? I never know what is going to be going on in someone else's life, frankly. This also relates to humility, or what adverse childhood events might account for particularly bad conduct. So my advice to you is don't judge, just move on. At the same time, just because you forgive or because you are tolerant doesn't mean you have to get run over, but it does mean that you don't let the person occupy your thoughts, which is a colossal waste of time. I've heard it described as not letting someone else rent space in your head. Justified anger can be a motivator, but it can also cloud your judgment and occupy way too much emotional time and energy that is better used on almost anything else. So I'll tell you a brief story. Take a cue from the Amish. Many of you may recall that the Nickel Mine School massacre, which happened in Lancaster County, Pennsylvania. And there on in October of 2006, Charlie Roberts, a quiet gentleman from all reports, burst into a one-room schoolhouse. Roberts was heavily armed. He ordered the teacher and the teacher's aide and all the boys to leave the schoolroom. Then he bound 10 young girls and lined them up against a blackboard. Roberts shot all 10 girls before killing himself. He killed 5 and the others were severely wounded. So what's perhaps less known about the story is the response of the Amish community. The same day as the mass killing, family members of the victims came forward with statements of forgiveness for Charlie Roberts. Members of the Amish community visited the home of the Roberts family to console them in their own grief. And Charlie Roberts' widow was invited to one of the young girls' funerals. For the Amish, forgiveness was required by their faith, but it was also not simply an act of grace. It was a way for the community to move on. There is a lesson there for all of us. So my final suggestion is look for the joy in the practice of law, or at least some degree of satisfaction. So, we all have days or stretches of work that leave us exhausted and full of questions. I mean, I always knew it was time for a reset when I would be driving to work and I think, I could be teaching history. I am firmly convinced that you can find joy in the practice of law. For me, it isn't a hallelujah chorus of joy with fireworks and brass bands. It's more the quiet kind of deep satisfaction that comes from knowing, despite whatever the result might have been, that we have done a good job for our client. We are a very privileged group to be given the opportunity to help others. And I know that each of you, no matter where you are working or the nature of your practice, have found that opportunity and have felt moved or exhilarated or deeply satisfied. Remember that feeling and come back to it on those days when work has become a slog or you can't stand the thought of reading one more nasty gram from opposing counsel. Remember that feeling and it will sustain you in the long run. So that's all I got. Lovely seeing all your names. And, don't forget, Melissa's telling you to report your attendance for CLE credit and to complete the form at that email address. I wish you all absolutely the very best of the season and hope that you will continue to take advantage of this great practice of, free CLEs for recent graduates and alums. All right, so take care, everyone.
Thanks, everyone.
Thank you.
Everyone, happy holidays.